This is part 2 of the 3-part series titled Something Old, Something New: The Criminal Enslavement of 500,000 Black Colonials and Afrofuturism in the 21st Century by Larry Kenneth Alexander. The History of Colonial Slavery. America's historiography has conflated its hereditary slave scheme with the Atlantic slave trade practice to mask the unlawfulness of enslaving and exploiting legally free black Englishmen after the American Revolution ended in 1783, enslaving 500,000 black colonials, denying them fundamental due process of law, and establishing a hereditary slave-based economy, making them the cornerstone of America's economy, were all wildly outside the English rule of law and international norms, as slaves under colonial slave codes and Negro laws were abolished before the Declaration of Independence by way of the American Colonies Act, 1766. However, colonial slavery's origin and the English rule of law eviscerate these long-standing narratives. Further, it is reasonable to conclude that an objective review of Parliament's Legislative Act in 1766 will evidence that the British imperial government abolished all repugnant colonial resolutions and resulting hereditary slave ordinances and Negro laws enacted by the colonial assemblies in the American colonies because they denied and questioned Parliament's exclusive legislative power and authority to legalize slavery in the kingdom, which returned enslaved black colonials to status quo ante, a legal free Englishman status possessed when independence was declared in 1776. Future readers must understand that the Atlantic slave trade was a separate and distinct form of human exploitation from what was being practiced within the 13 British American colonies during colonial times. Under the English Magna Carta of 1215 and English common law, slavery was rejected as a lawful practice on British sovereign soil. The 13 colonies in America were all British sovereign soil, as England's monarch granted them a colonial charter, but without the legislative authority to enact slave laws. English law was why the first 19 Africans who arrived in the colony of Virginia in 1619 were indentured servants, not slaves. Moreover, colonial slavery in the American colonies violated the English Magna Carta of 1215 and English common law. It was an extra-legal slave practice within the 13 British American colonies because such slave laws enacted by a sole house of each colonial legislature violated colonial charters and were legal nullities. The extra-legal practice of colonial American slavery began in the early 1640s and spread throughout the 13 American colonies due to colonial government corruption and racial tyranny. Furthermore, the British imperial government legislatively abolished all colonial American slave codes and Negro laws by way of Parliament's American Colonies Act of 1766, 10 years before America's Declaration of Independence. Parliament's supreme lawmaking authority over colonial America's slavery was affirmed by England's Court of the King's Bench in the landmark James Somerset versus Charles Stuart case in 1772. Colonial America's slave codes and Negro laws violated each colonial charter and the English Bill of Rights of 1689, as they denied and questioned Parliament's exclusive positive lawmaking power, and as well, England's Magna Carta of 1215, Article 39. This provision in the Magna Carta provided, "No freeman shall be taken or imprisoned or disseised, sick, or exiled or in any way destroyed, nor will we go upon him nor send upon him, except by the lawful judgment of his peers or by the law of the land." This clause enshrined England's common law principle of personal liberty and due process of law. These principles laid the groundwork for later legal and substantive arguments against the institution of slavery. Future abolitionists came to rely on the Magna Carta to argue that slavery in the kingdom violated the natural right to liberty and the rule of law that the English Magna Carta announced. While England's Magna Carta distinguished between free men and others, e.g., serfs, who were tied to the land, its principles of freedom were later extended in legal and moral debates to argue that no person, regardless of status, could be enslaved under English law. This interpretation aligned with rulings like the Cartwright's case, 1569, an essential early English legal decision that established that slavery was not recognized under English common law. Specifically, this case held that a person cannot be held as a slave in the kingdom. The report of the Cartwright's case allegedly states, "The air of England is too pure for any slave to breathe," and this principle essentially declared that any person who set foot on English soil could not be considered a slave, as slavery was inconsistent with England's common law. This legal ruling became a significant precedent in English jurisprudence and contributed to the abolitionist movement decades later, influencing cases like the Smith versus Brown and Cooper case, 1702. Thus, in 1619, when the first 19 or 20 kidnapped Africans arrived in colonial Virginia, the lawgivers in Virginia applied the English common law, explaining why the original Africans became indentured servants, not slaves. Indentured servitude was a brutal and deadly status. Many people died well before their terms were over. But indentured servitude was temporary, with a beginning and an end, typically 6 to 9 years. Afterward, these Africans, no different from other immigrants, became British subjects when they completed their term of indenture. Thus, these original 19 Africans became members of the political community formed and brought into existence by the Constitution. They were treated no differently than other colonists, such as Benjamin Franklin, who served as an indentured servant in colonial America. Further, history supports that these Africans were then eligible for head rights for land in the new colony in the Chesapeake Bay region, where indentured servants were more common. Additionally, all children, including the children of the original Africans born within colonial America, were born free British subjects. Their British subjecthood was based upon England's common law doctrine of jus soli and the colonial charter, and England's king protected all children. No English person could be born a slave, and being born in colonial America made the person a free-born Englishman with an unalienable right to liberty under the English Bill of Rights of 1689 and the colonial charter. Virginia's colonial charter provided for a bicameral legislative structure with England's king and a colonial assembly headed by a colonial governor appointed by England's king. Virginia's colonial assembly, the House of Burgesses, had no legislative power or authority to legalize slavery or to pass colonial resolutions, votes, orders, ordinances, and proceedings without first acquiring the assent of the British imperial government. Moreover, the Parliament of Great Britain strengthened the rule of English law by passing the Sedition Act of 1661. This self-executing act of Parliament made it a treasonous offense to suggest or to promulgate a legislative power without the king. Thus, the rule of English law and Virginia's charter created a significant legal challenge to Virginia's hereditary slave ordinance, Negro laws, slave codes, and resolutions from becoming lawful during colonial times in colonial America. Mindful of the fact that slavery within colonial America was not allowed and approved under the English rule of law and was a crime, Virginia's House of Burgesses, its colonial assembly, pretended to enact an ordinance called Partus Sequitur Ventrum, which purported to change the patrilineal descent law of Partus Sequitur Patrum for people of African ancestry in 1662. The colonial ordinance provided, whereas some doubts have arisen whether children got by any Englishman upon a Negro woman should be slave or free, be it therefore enacted and declared by this present Grand Assembly that all children born in this country shall be bond or free according to the condition of the mother. Virginia's 1662 colonial ordinance of Partus Sequitur Ventrum decreed that children of pretended enslaved mothers would be born into slavery, regardless of the English rule of law and Virginia's colonial charter that conferred English subjecthood to all individuals born in the colony of Virginia, jus soli. The speciousness of Virginia's hereditary slave ordinance is quickly revealed, since there was no legal condition known as slave recognized by English law throughout the Kingdom of Great Britain in 1662. Further, this colonial law did not have the weight of being a law, since Virginia's colonial legislature was bicameral and violated England's Magna Carta of 1215. Nonetheless, the 12 other colonies within British colonial America followed Virginia. They enacted similar hereditary slave ordinances and Negro laws in violation of their colonial charters and without the approval of the formal British imperial government. Colonial American slavery was a criminal enterprise that thrived due to the systemic corruption of colonial governments, graft, and racial tyranny, which caused Africans and colonial-born blacks living in the American colonies to be treated as personal property. These slave-holding Englishmen were integral participants in the colony of Virginia's hub and spoke conspiracy as the extra-legal practice of hereditary slavery became endemic throughout the 13 American colonies. Colonial-born blacks and kidnapped Africans brought to the American colonies had legal rights under the English Magna Carta of 1215 and later England's Bill of Rights of 1689 and English common law, and yet people of apparent African ancestry were treated like livestock due to colonial governmental corruption and racial tyranny. However, colonial slave codes and Negro laws were void ab initio, since none of the colonial assemblies were conferred the legislative power and authority to enact a positive law to legalize slavery within a British colony. Furthermore, Parliament's English Bill of Rights of 1689 announced fundamental liberty rights to colonial-born blacks, which were announced in the Magna Carta of 1215 and the English common law. By pretending to pass hereditary slave ordinances, resolutions, votes, orders, proceedings, and Negro laws, each colonial assembly within the 13 American colonies exceeded their grant of legislative power and authority and were specifically denying and questioning the power and authority of Parliament. During the late 17th century and the beginning of the 18th century, harsh new slave codes or Negro laws limited the rights of people of African descent. They cut off their avenues to freedom within the American colonies. Further, Virginia's Colonial Assembly in 1691 prohibited colonial slaveholders from emancipating enslaved blacks unless they paid for the freemen's transportation out of the colony of Virginia. And this colonial assembly began condemning mixed-race children of free white women to serve as indentured servants for 30 years. Virginia's assembly subjected the white mother to a 15-pound sterling fine. As punishment for having a mixed-race child, the mother would be indentured for 5 years if she failed to pay the ascribed fine within a month of the birth. The colony of Virginia also criminalized interracial marriage in 1691, and subsequent Virginian laws abolished free blacks' rights to vote, hold office, and bear arms. It is a dispositive fact establishing colonial slavery's unlawfulness that the colonial American assemblies failed to secure the formal approval of England's king regarding their so-called slave codes and Negro laws, especially since Parliament passed the English Bill of Rights of 1689. Parliament's legislation in 1689 made it plain that hereditary slave ordinances and Negro laws, which relegated black colonials below the rule of English law, were denying and questioning Parliament's supreme legislative power and authority over the British American colonies. Nonetheless, the British imperial government did not immediately enforce the rule of English law within the American colonies, as it had an unofficial policy of salutary neglect when it came to colonial governance, but that came to an end in 1766 when Parliament finally passed the American Colonies Act of 1766. commonly called the Declaratory Act, 1766. Virginia's Colonial Assembly, as historian Betty Wood, in her book Origins of American Slavery, observed that the colony of Virginia codified and systematized slave laws in 1705. She stated, "These laws would be modified and added to over the next century and a half, but the essential legal framework within which the institution of slavery would subsequently operate had been put in place." However, all colonial slave legislation and Negro laws throughout the American colonies were legislatively abolished due to Section 2 of Parliament's American Colonies Act of 1766. These so-called slave codes and Negro laws throughout the 13 American colonies were legal nullities since they exceeded the legislative authority granted by British colonial charters to each respective 13 colonial assemblies. Moreover, all of these colonial slave legislative proceedings denied and questioned the supreme legislative power and authority of England's Parliament and were rendered null and void for all purposes whatsoever in 1766. This Act of Parliament in 1766, 10 years before the Declaration of Independence, fundamentally altered colonial governance within the American colonies as it rendered all resolutions, votes, orders, and proceedings enacted by colonial assemblies null and void if they denied or questioned Parliament's supreme powers and plenary authority to legislate over the American colonies in all cases whatsoever. Afterward, in 1772, the Court of the King's Bench affirmed parliamentary sovereignty in the James Somerset versus Charles Stuart case, where England's highest court struck down colonial America's slave codes and Negro laws with its ruling. Slavery was not allowed and approved by the laws of this kingdom. It could only be lawful by a positive law, a power which only Parliament possessed and had not exercised. Most importantly, after the Declaration of Independence in 1776, the U.S. Congress fastened this new nation to the rule of English law by formally adopting Anglo-Saxon jurisprudence and English law over Thomas Jefferson and others' strong objections. They advocated for a clean break from England and English law and its legal precedent. Jefferson wanted Congress to adopt Roman law, perhaps recognizing that this would offer the U.S. matrilineal ordinance of partus sequitur ventrum during colonial times the best opportunity to legitimize its hereditary slavery practice and their ownership claims of colonial blacks. Jefferson was unsuccessful. And in addition, each state government in the United States specifically enacted reception statutes, adopting the English common law after the American Revolution ended, and adopted English law as the basis of the U.S. Constitution. Further, the legal conclusion that the 500,000 black colonial living in the American colonies, who became the bedrock of the United States slave-based economy, held British subjecthood, and were not the legal property of white patriots, is the grievance section in the Declaration of Independence in 1776, where the Founding Fathers are found admitting that the British imperial government had already abolished their most valuable laws. Functionally and legally, the adoption of the English rule of law by America's Congress and the U.S. Supreme Court made England's Magna Carta of 1215 and England's rulings regarding colonial slavery in the Somerset case the law of the land. Declaration of Independence. The Declaration of Independence unequivocally proclaimed that these united colonies are and of right ought to be free and independent states, that they are absolved from all allegiance to the British Crown. This language formally declared political absolution, severing all obligations to British rule. Lysander Spooner, the 19th century legal theorist and abolitionist, rigorously analyzed the Declaration, asserting in his 1860 work the unconstitutionality of slavery, that it was not merely a historical document, but a legal constitution. He correctly argued that its principles had profound implications for interpreting slavery's legality under the U.S. Constitution. Thomas Jefferson, a lawyer and slaveholder from Virginia, was acutely aware of this reality as he carefully drafted the Declaration in 1776. He also knew that Parliament's American Colonies Act of 1766 had abolished colonial slave codes and that Lord Chief Justice Mansfield, in Somerset v. Stewart, 1772, had affirmed parliamentary sovereignty. Of the 56 signers of the Declaration, 25 were trained lawyers, including John Adams of Massachusetts and John Jay of New York, both of whom were morally opposed to slavery. Historian John R. Howe, Jr., in his article John Adams' Views of Slavery, published in the Journal of Negro History, highlights Adams' firm belief that slavery and the slave trade were an infamy and that every measure of prudence should be taken for their eventual total extirpation. Unlike many of his contemporaries, Adams never owned enslaved people, an unusual stance for someone of his social and political standing in the 18th century. Historian Arthur Scher, in John Adams' Slavery and Race, Ideas, Politics, and Diplomacy, explores Adams's complex views, emphasizing his moral opposition while also noting his reluctance to make slavery a central political issue. Though unwavering in his personal stance against slavery, Adams prioritized national unity over aggressive abolitionist advocacy during his political career. John Jay, in contrast, actively supported abolition. As the first Chief Justice of the United States, 1789-1795, his legal expertise shaped his political work, including his efforts to end slavery. Scholar Richard B. Morris, in John Jay. The Nation, the Court, and the Early American Statesman examines Jay's attempts to reconcile revolutionary ideals with the grim reality of slavery. Historian Sean Wylance, in No Property in Man, Slavery and Anti-Slavery at the Nation's Founding, details Jay's involvement in early anti-slavery efforts, emphasizing his commitment to gradual emancipation while navigating political constraints. Adams, Jay, and other anti-slavery members of the Continental Congress understood the necessity of crafting a declaration that would resonate with multiple audiences: the British government, colonial citizens, and the international community. They structured the document like a legal brief. 1. The preamble, justifying independence. 2. A list of grievances against the British Crown. And 3. A formal declaration of independence. The final text was intended as a statement of fact, asserting that the colonies were no longer legally or politically bound to British rule. However, Jefferson's original draft included a pointed condemnation of King George III for blocking colonial attempts to limit or abolish the importation of enslaved Africans. He wrote that the king had waged war against human nature to restrict or abolish the importation of kidnapped Africans, violating its most sacred rights of life and liberty in the persons of a distant people who never offended him, captivating and carrying them into slavery in another hemisphere, or to incur miserable death in their transportation thither. This passage was Jefferson's attempt to deflect from the reality that Parliament had already legislatively abolished colonial slave codes and that Somerset versus Stewart had affirmed parliamentary sovereignty. Moreover, throughout the Declaration of Independence, there were numerous complaints that England's King George III was refusing to give his assent to their Assembly's efforts to pass wholesome laws, which underscored that colonial assemblies had no legal authority to enact colonial laws independent of the British imperial government. By excising Jefferson's indictment of the Crown and then rejecting Jefferson's push to sever the new nation legal ties to England, and then adopting Anglo-Saxon jurisprudence and English law as America's first Congress, Jefferson was frustrated and forever lamented that Congress had mangled the Declaration. His grievance was justified as failing to sever ties to English law and then formally adopting Anglo-Saxon jurisprudence and English law after declaring independence. Congress did not sidestep the legal reality that colonial slave codes had already been abolished and were affirmed by the British highest court, which made the Declaration's statement of independence fundamentally at odds with the perpetuation of American slavery. Please continue with Part 3 for the final session.